and they saw the 2-year-old just crying on top of their mother.
And you shot her right in front of her kids. Punk ass.
Hey, okay. All right. Anyone who's back there speaking, you're out. Anyone who is talking, get out. Bring him back. Come here. You're coming up here.
Well, welcome.
Okay. Hey, I understand that this is an emotional thing. I have the right at this moment to find you in contempt for your behavior and sentence you to jail for up to 180 days. Do you understand that? Do you understand me? Get out. But that behavior cannot continue.
What do you think an appropriate sentence would be?
Eye for an eye. Death penalty.
After killing Kalia, the defendant fled and left Kalia there for her 2 children to find.
The trauma that they were exposed to, the fact that you shot Ms. Bell and then left.
This sentence
We're set for sentencing this morning. Are both sides ready to proceed?
To bring up the state prior to beginning this morning advised me that they were going to submit for the court's review a poster which contains a picture of the victim and some other photographs, as well as a collage of photographs, separate collage of photographs as well. And I don't think they're appropriate for purposes of sentence.
Okay, I'm going to say one thing before we get started, because I do understand that this is a very emotional event. However, there cannot be comments that are made from the gallery during our hearing. There can't be outbursts, anything of that nature, or you're going to be asked to leave. And I don't want to have to ask anyone to leave. I know it's important for all of you that you're here. Moving forward, unless you're speaking as a witness, you have to remain quiet during the hearing. I'll let the state respond to Mr. Lenyo's statement.
Thank you, Your Honor. There's multiple family members of Kalia, who's the victim in this case. Kalia's mother did bring the poster, and she just wants the court to see it. It's just pictures of Kalia. There's nothing graphic or extravagant in it. And the other one is an 8 or 11 by 14 maybe picture frame with just about 7 or 8 pictures on it. I think her family just wanted the court to be able to see Kalia and for Kalia to have a presence. It's just 2 exhibits, and I don't believe it to be extravagant.
All right. So I don't see anything inappropriate with having pictures shown at sentencing. I don't think they are things that would be admitted as exhibits. I think they are, I guess, demonstrative, for lack of a better word.
Yes, Your Honor.
And so showing me those pictures, I don't think sort of crosses any lines of propriety or appropriateness at a sentencing hearing. But I will let the state sort of present, display, hold, whatever the case might be, with the demonstrative exhibit, the pictures. If the witness wants to refer to them or discuss them in some way, that's fine. But it will be sort of for that purpose, not admitted as an actual exhibit.
Thank you, Your Honor.
So presumably the state has witnesses. How many witnesses is the state calling? Okay. And then Mr. Lenyo, do you have witnesses?
No, Your Honor.
Okay. And so what we'll do is start with witness testimony, and then we'll, from that point, move into discussion about the sentencing, and we'll talk, I guess, a little bit more about that then. But just to reiterate, the plea in this case was to count 2 voluntary manslaughter as a level 2 felony, as well as to the felony firearm sentencing enhancement. And both sides are free to argue. And so there's a sentencing range of 10 to 30 years on count 2, with an advisory sentence of 17.5 and a potential enhancement of 5 to 20 years in addition. Do I have that all correct from both sides?
Yes, Your Honor.
Point of view?
Yes, Your Honor.
Okay. All right. So like I said, we'll take witness testimony first, and then we'll let both sides speak to sentencing. Ms. Harmon?
Morning, court.
Can you tell me your name for the record, please?
My name is Nick Eugene Farr.
And can you spell your last name, please?
Farr.
Thank you. Ms. Harmon?
Thank you, Your Honor. Mr. Farr, how did you know Miss Kalia Bell?
She's my niece.
And did you help raise her?
Somewhat. I mean, I'm sister's oldest brother, and
you came here today. Are you speaking on behalf of multiple family members?
yes, ma'am.
And what would you like the court to know for sentencing today?
That this man took a part of our lives that we'll never get back. That you devastated our family, and it takes a whole for me to not trip on you.
Now, Mr. Farr, I know this has been very difficult.
You took a part of our family we'll never get back because you was mad. And my niece lived in that house that you was a guest, and you shot her right in front of her kids. Punk ass.
Hey, okay, all right. Anyone who's back there speaking is going to leave now. Nope, you're out. And sir,
Yes,
you're
ma'am.
speaking to me, not to him. That's what this is about. Not yelling at him, but speaking to the court. Out. Anyone who is talking, get out. Excuse me, no, bring him back. Come here. You're coming up here.
That's my little brother, Your Honor.
You can be quiet.
Welcome.
Okay. Hey, you have disrupted this court process. I understand that this is an emotional thing. I have the right at this moment to find you in contempt for your behavior and sentence you to jail for up to 180 days. Do you understand that?
When the judge brought the brother back in and basically said, you can sit quietly or you can sit in a cell, that wasn't heartless, that was control. Courtrooms can't turn into street justice just because the crime is horrific. I understand why he snapped, but the judge's job isn't to feel what he feels. It's to keep the process intact.
What do you have to say for yourself? Think about what language you're about to use. You are out. You are leaving. You are not to come back. Do you understand me? Get out. Do not say another word. All right. So we had this conversation before this hearing started for this very reason. And again, I am not issuing a contempt finding because I do understand that this is a very emotional experience, but that behavior cannot continue. And all of you who responded to it cannot do that. If I hear another sound from anyone in the back who is not a witness here at this proceeding, as much as it would pain me to do so, I will ask you to leave. If I were the family member of a victim in a similar situation, I would want to stay and I would want to be there for my family member. If my family member was the person sitting here, I would want to be there for that family member. It should not be so important to have such an outburst that you would be asked to leave because it is more important that you are here for your people. So just try to keep that in mind as we move forward, please. Sir, I will say this to you. This is not your opportunity to yell at Mr. Dockery. This is your opportunity to speak on behalf of your family to the court, advising what you think, advising how this has impacted your family. You have done that, and I understand that. And advising the court what you think should happen as a result of this sentence. This is not your opportunity to yell at Mr. Dockery. That is not what this is for. So if you have anything else you wish to say about those things that I said, you are free to do so. Beyond that, I'm going to ask you to leave.
I apologize to you, court, Your Honor.
All right, Ms. Harmon.
Mr. Farr, you and your family put together some pictures and a poster of Kalia, correct?
Yes, ma'am.
And is that something you would like the judge to see?
Yes, ma'am.
May I approach the witness, Your Honor?
You may.
I need to stand up.
Yeah, Your Honor, maybe step up.
Am I helping with the poster?
No, they can
not a
hold the
threat.
poster.
I'm not a threat, Your Honor.
I understand that. You can stand up. It's fine. But you will stay right there.
Explain to the judge what you and your family also put together the pictures on
Can I
a
stand up, Your Honor?
You may.
Thank you.
And what are the pictures in the framing in front of you?
Yes, ma'am.
Are these of Kalia?
There's our mother, my sister, grandmother to Kalia. This is Kalia, her mother, Kalia's daughter, and a family friend. That's Kalia. That's Kalia. That's me holding Kalia. There's my brother Omar that just got kicked out. The mother, Omar, mother, our mother, and Kalia's mother. And that's Kalia and her friend. Those happy days are gone.
Thank you.
Yes, ma'am.
Ages of the children?
If you're going to document my response to a specific age, no, I don't know their age.
Were they
It's
young?
specific?
Well, I guess now would be about 9 and 5. Does that sound right?
When they were murdered in front of their mother, how old were they? Is that what you're asking me?
That's fine. Do you know?
Too young to remember. And I doubt that they wouldn't remember because we all got a good memory in our family.
And one of the things that we're asking you to speak on is what you think an appropriate sentence would be here.
Excuse me?
What you think an appropriate sentence would be here. And you heard the judge. I don't know if you were able to hear the judge listed the sentence range and what Mr.
I did hear
Dockery
it.
plead to. And based on how this has impacted your family and the totality of the facts, what do you think an appropriate sentence would be?
Eye for an eye, death penalty. But I know that ain't going to happen. So life.
Most families ask for the maximum sentence allowed. He asked for something beyond what the law even offers. That tells you where his head was at. When life doesn't feel heavy enough, you're not talking about punishment anymore. You're talking about pain that doesn't have a ceiling.
I have no additional questions, Your Honor.
Mr. Lenio, do you have any questions for this witness? All right, sir, you are excused. Thank you.
When pain turns into anger, the line between justice and revenge gets dangerously thin. But in court, emotion can't decide the outcome. Only the law can.
As well.
Thank you.
Mr. Lenio?
Thank you. Your Honor, Juwan Dockery is 25 years of age, born December 20th here in South Bend. Lived here, grew up in this community. He attended South Bend schools, graduated from Washington High School in 2019. While in high school, he played a number of sports. He was a member of the wrestling, basketball, and football teams while at Washington High School. He participated in 3 years of wrestling in middle school and 2 years in high school. He played 2 years of basketball in high school and 3 years of football in high school. He was also in the choir in middle school from the 4th grade through his 10th grade year. In high school, he was involved in a community-based program called 100 Black Men. This program was a history-based and community-based program which had fundraisers for charitable works and focused on public service. As he grew up, Juwan had no gang involvement. He has strong family support. His mother, Erica Dixon, has attended his court dates, is here today with some other family members, kept in contact with me. She's employed. She submitted a letter on Juwan's behalf. A number of Juwan's family members have been members of the military and law enforcement. His uncle, Michael Miller, is a retired deputy sheriff with St. Joseph County. His aunt, Brenda Brooks, submitted a letter on Juwan's behalf. She's a retired Army veteran. Juwan has been in the county jail for a considerable period of time, 825 credit days, as of February 5 of 2026. During that time, he completed a program called Jails to Job Workshop, which was held by the University of Notre Dame's Institute for Social Concerns. They did issue him a certificate. I've provided that certificate to the state and like to submit this as Defendant's Exhibit A for the court's consideration.
Then the defense holds up a jail program certificate like that's supposed to balance out a homicide. I'm sorry, but that doesn't move the needle much. Participation in a workshop doesn't erase what happened. Judges look at accountability and harm, not attendance sheets.
Juwan has a good conduct record at the jail as well. He had no juvenile record or involvement with police as a juvenile, as shown by the pre-sentence report. His criminal record contains no prior felony convictions. He does have 3 misdemeanor convictions, which include a misdemeanor conviction for resisting law enforcement in 2019, a possession of marijuana charge in January of 2022, a resisting law enforcement misdemeanor conviction from October of 2023. In that case, he was on probation in that case, had a 30-day suspended jail sentence, and in that case, the court had ordered a credit report. He has 1 day of jail credit in that. What we would suggest is the court to impose the 30-day sentence, give him credit for that 1 day, and take days from his 825 days to satisfy that sentence in full. Juwan is single, never married, has 2 children. He has a son, Jamarius, age 5, a daughter named Lovely, age 2. Both children have his last name. There's a support order for Jamarius, and there are some support urges owing for Jamarius, as Juwan has been incarcerated for over 2 years. At the time of the offense, Juwan had just started a new job at Tire Rack. He had also worked in 2023 for approximately 6 months at Global Parts Network. There is a substance abuse history. He could benefit from receiving some drug and treatment we'd request an order that he be permitted to participate in the recovery while incarcerated program. There's also a mental health history as well, which has been documented by reports in this case by Dr. Chisholm Buggs, Dr. Linda Monroe, and Dr. Jeff Burnett. Dr. Chisholm Buggs diagnosed Joanne with unspecified schizophrenia spectrum and other psychotic. He did receive competency restoration services in this case, which were successfly concluded. He's currently taking Lexapro as a medication administered at the jail. While not amounting to an insanity defense, his mental illness should be considered to be a mitigator in this case. In terms of a sentence, we're requesting that this court impose a 20-year sentence on the voluntary manslaughter convictions with 10 years suspended. As to the firearm enhancement, a 5-year suspended sentence would be appropriate under the facts of this case. Juwan did not own a firearm and never has owned a firearm, nor has he had any cases or reports of him misusing or possessing a firearm or involved in any type of activity with a firearm. The firearm was owned by the victim in this case and kept in the household, which Juwan shared with her. Again, there's no history of gang involvement or running the street with guns. So defense believes that the firearm enhancement should be at least at the lower end of the range and be suspended. That includes my sentencing request, Your Honor.
Great, thank you. What's the state's position? Sir, you do not have an opportunity to speak anymore. What's the state's position?
Thank you, Your Honor. Aggravating factors do include that the defendant was on probation at the time of the offense and he has prior criminal convictions. Looking at the higher pre-sentence investigation, I believe that it's clear that the defendant is clearly a future harm to any community he's in. So we believe that with the aggravating factors and the high risk of the defendant, that a higher executed sentence above the advisory is appropriate. The state's witness had mentioned that the two children were present. They were not technically in the room when Ms. Bell was shot. However, they were in a neighboring bedroom. And the 7-year-old had a memory of waking up to what she thought was a gunshot and then going back to sleep. And after killing Kalia, the defendant fled the scene and left Kalia there for her two children to find, which they did. The 2-year-old found their mother dead in her bed. And the 7-year-old went to get help and came back with an adult neighbor, and they saw the 2-year-old just crying on top of their mother. There are multiple aggravating factors present here, including the facts surrounding the case itself and the defendant's actions. So we believe that we agree partially with the pre-sentence investigation recommendation. On count 2 of a 25-year executed sentence, we do agree with that. On the firearm enhancement, we're asking for the max of the 20-year enhancement, 15 of that to be executed, so a 40-year sentence plus an additional 5 years of probation upon release. Thank you, Your Honor.
Great, thank you. Mr. Dockery, is there anything that you wanted to say?
Yes, ma'am. Thank you, Your Honor, for giving me the opportunity to speak on my behalf. I would like to say that I apologize and I take accountability for the actions and the pain and hurt that I caused Kalia's family. And it eats me up every day, and I think about it and I relive it. And I just want them to know that I am truly sorry, and I hope that they can forgive me, find it in their hearts to forgive me for the actions and the pain that I caused their family. And I will ask for forgiveness from them. And I just pray that they just forgive me. Thank you, Your Honor.
Thank you. All right. Mr. Dockery, when you pled guilty, we talked about the fact that I would consider aggravating factors and mitigating factors to determine what sentence would be appropriate within the sentencing ranges we discussed earlier. In mitigation, I take into account the fact that you are a high school graduate, that you had some history of employment, and that you pled guilty and admitted your responsibility in this case. I temper the plea agreement a bit by the fact that there was a reduction in the charge, but I also recognize that even with that, it's a free to argue plea. The court has the discretion within that sentencing range to sentence you. So I do give it some weight, the fact that you pled guilty, even though you did receive a benefit as well. I also do take into account the mental health history. I think we did have that documented throughout the pendency of this case, both through the competency evaluation.
Now the judge begins breaking down the factors that will decide the defendant's future: mitigation, aggravation, responsibility. Every detail matters. And as the reasoning unfolds, it becomes clear that this sentence will reflect not just the act itself, but the impact left behind.
Specifically, I think, and mostly, you were on probation for that misdemeanor we're here for as well at the time of this offense. I do take into account as well that this offense occurred in the presence of children. And I recognize, I think, the state's distinction that maybe the children were in a different room when the actual shooting occurred, but I don't think that mitigates the trauma that they were exposed to, especially in light of, and again, now taking into account the facts and circumstances of this case, the fact that you shot Ms. Bell and then left her there to die with her kids and they are present in the home. You didn't call for help. You didn't do anything to help. You just left. And these young children were then put in a situation where they found their mother, and a 7-year-old had to go get help. Not something that children should ever have to experience. But I consider that to be probably the most significant aggravating factor in this case.
The judge pointed out that the cruelty wasn't only in the act, it was in the exit. Leaving toddlers alone in that situation tells you a lot about priorities. Getting away mattered more than the kid's safety. That part is hard to even process.
So that being said, I do believe a sentence greater than the advisory sentence is appropriate. The sentence on count 2 will be a 25-year sentence. It will then be enhanced by an additional 15 years for a total 40-year sentence. You have, if I subtract out the 14 days at your request, Mr. Lenyo, on the misdemeanor 23 CM 1782 and apply those to that case, then there will be a remaining 811 days at Class B credit toward the sentence in this case, in the MR case. Mr. Dockery, you do get 1 day credit for every 3 days you serve in this case. So in real time, you're serving 75% of the sentence that I am imposing. I am going to suspend 5 years of the sentence and place you on probation for 5 years following your release from custody in this case. As a condition of probation, I'm going to order that you complete an IRAS assessment. Based on those assessment results, participate in any programming that probation refers you to. The other standard terms and conditions of probation will apply. So you will not use any controlled substances without a valid prescription. You'll submit to random drug and alcohol testing and pay for that at the direction of probation. You consent to your probation officer visiting you at your home, your place of employment, or elsewhere. And you may not purchase, use, possess, or exert control over a firearm or other dangerous device. If you violate any of these conditions of probation or commit any new offenses while you're on probation, probation can file a notice of violation. I will put on the abstract, Mr. Lenyo, that I would recommend that Mr. Dockery engage in both mental health treatment as well as substance abuse treatment while in the Department of Corrections. And so again, what the result of all of this is, Mr. Dockery, is a 35-year executed sentence to the Department of Corrections, followed by a 5-year suspended sentence to 5 years of probation. And as I explained to Mr. Lenyo, I will include on the abstract that goes to the Department of Corrections that it would be my recommendation that you engage in that programming while you're there. As I said, you have 811 days credit toward that sentence, that 35-year executed sentence. Is there anything further, Mr. Lenyo?
No, Your Honor.
Anything